One of the most important steps companies do is creating a board of directors. And there's going to be generally changes in the board of directors as a successful startup grows. The way corporations work is that directors are actually technically in charge of everything in the company, not the CEO or the president. Boards of directors delegate powers to the CEO and president, but what they delegate they can take back. And of course, when you get right down to it, boards of directors are the ones who hire and fire CEOs, CFOs, presidents of the organization. So when you ask who has the principal power in an organization, it's the directors. You might say, well, look, the shareholders vote for the directors, so surely they're the ones in charge. But in practice, that's not actually how it works out in corporations. Shareholders don't have enough information. Their ability to interfere and affect what goes on in a business is extremely limited by law. Really, for the most part, their big right is to vote for the directors. And mostly they just vote for whomever the directors say they ought to vote for. So the directors are really the ones in charge. A lot of the, so directors are the key body to concern yourself with in a startup. What's the best structure for a board of directors? In my opinion, the best structure for a board of directors is to have a majority independent board. That means that you've got one or two insiders, that is people, usually the CEO will be on the board and maybe one of the other founders will be on the board. And then you have three directors, let's say, who are independent. And you want to make these people as impressive as possible. You want them to be smart, engaged, successful, experienced in the industry that you're in. And the reason you do this is because directors are incredibly useful for getting other investors to put money into a business. Directors, if they're part of a business, confer certain respectability on the business. People go, well, so-and-so is a very smart person. He understands this space, and he's a director of this company. I should feel confidence investing in it. Also, the people ultimately who are responsible for how the money is going to be spent that an investor puts in are the directors. And so people of integrity and expertise, competence, are reassuring to an investor, going, well, so-and-so isn't going to blow my money. This will be carefully spent. But the biggest reason, in lots of ways in practice, to have a good, competent, independent board is that it will forestall big fights with sophisticated investors. At some point in a company's financing plan, as it gets bigger, it's going to encounter investors putting in a proper amount of money, $1 million plus, maybe an angel investor, maybe an institutional investor like a venture capitalist. It may be a brokered private placement with an investment bank raising the capital. At some point, it's going to encounter sophisticated parties in its financing. And those sophisticated partners will be very, very focused on the board of directors because they know everything I've told you in this interview. And as a result, there's going to be intense pressure on a company that if they want the money to put what these investors have selected as directors. And sometimes those individuals aren't people that the management team feels really comfortable with or feels confident in. And the best way to forestall this argument is to already come with a board of directors that is as good as anything anyone else could put in. And that way, if you have a conflict between the venture capitalist and the company, there's a way to resolve it. And that is through your independent directors, who are neither appointees of the venture capital fund, they're not appointees of the insiders, they're men of integrity and competence, men and women of integrity and competence, and both sides trust them. Look, if I have a strong disagreement with the venture capitalist, or if I have a strong disagreement with management, I trust these guys will be able to adjudicate the dispute and know the right thing to do, and vote either with me on the board or with my opponents on the board if they're right and I'm wrong. So that's incredibly valuable. There's also, a good board brings in moral authority. Disputes often arise among and within a management team. Startups are volatile places, and you're constantly changing your strategy, constantly rethinking who ought to be in charge of something. It's very useful to have a party that's above the fray, that everyone respects, and have them be the ultimate court. So if you're going to create a good board of directors, you need to, one, plan on paying them. And you're not going to probably pay them very much in cash because startups don't have very much cash. But you're going to need to be generous with equity grants. And that runs contrary to the instincts of most people in a startup, whose attitude is if you're not here 12 hours a day like everybody else, you shouldn't get very much equity, if any. The reality is directors are liable for companies. They're prone to getting sued when things get wrong. Most sophisticated investor and director candidates will understand that this is a risk, and you need to give them a reward commensurate with that risk. You've got to induce them to put their names on the line, to roll up their sleeves, to get involved. I've been a director of lots of startups, and it's not a picnic. And so you can plan on being generous with equity with your directors. And you also need a way to help them manage their downside, manage the risks of being a director, lower the risk profile. And you do that two ways in Canada. The first is you provide indemnification. And these are promises by the company that it will pay the director's legal costs and the costs of any damages awarded against the director, provided the director didn't breach the fiduciary duty. That is, provided the director didn't enter into a conflict of interest or willful misconduct or fraud, that sort of thing. The problem with indemnifications is they're not any good in a bankruptcy. And most startups, before the lawsuits start flying, they've gone bankrupt. Because of course, once a company's bankrupt, it's got no money to pay on an indemnification. But indemnifications are useful, particularly if a startup doesn't really succeed, gets sold to another company, which is often how investors exit a startup. That other company then decides it wants to sue the officers and directors. Indemnification means that if they sue the officers and directors, they're suing themselves. You shouldn't rely on indemnification provisions in bylaws. You shouldn't rely on indemnification provisions in this Corporations Act. There should be a standalone indemnification agreement that provides directors with money up front, that provides them for indemnification for everything except breach of their statutory fiduciary duties. Anyways, so that's indemnifications. Because when a company goes bankrupt, indemnification isn't worth anything, and that's the usual scenario a director worries about, you also need to think about getting directors and officers insurance. Directors and officers insurance, in particular, and this is an obscure term, for which I apologize, but it's called Side A coverage. Side A coverage is owned by the directors and is only paid to the directors, and it's the only kind of coverage a startup needs. Often, brokers will try to sell you Side B and C coverage. It's unnecessary and irrelevant for most startup and growth companies. What you need is Side A coverage, and you don't need very much. It's actually very difficult to successfully sue a director. 99% of the risk a director faces is actually just having to spend their money defending themselves. And so, provided the directors didn't ever enter into a conflict of interest, provided that they weren't self-dealing. But if they weren't self-dealing, it's legal fees only that they have to worry about. And so you don't actually need very much directors and officer insurance, just a few $100,000 to make sure the directors can mount a robust defense. And so while D&O insurance is often quite expensive, you don't need very much of it, and that tends to reduce the costs.
Cool.
Good?
Yeah.